I'm talking about the other threat to our republic, which is the mob violence and lawlessness and ethical breakdown associated with the opposition to Brett Kavanaugh to become Associate Justice of the Supreme Court. Thankfully, the Senate rejected that lawlessness, did not succumb to mob rule, did not let the effort to destroy ethics and destroy Kavanaugh stop him from voting him, Kavanaugh, into the Supreme Court, onto the Supreme Court, for which, a position for which he was eminently qualified. But the way things work in Washington, if something happened 2 weeks ago, Washington doesn't want to care about it anymore. Especially if caring about it forces Washington politicians to do uncomfortable things. And the most uncomfortable thing for many Washington politicians to do is to hold people to account under the law. They don't like doing it. They don't like doing investigations because it involves doing that. They don't like doing hearings because it involves doing that. And they don't like requiring the Justice Department or forcing executive branch agencies to obey and follow the law in terms of going after misconduct like was uncovered a few weeks ago in the effort to destroy Kavanaugh. So that's why, again, it's up to groups like Judicial Watch, or a group like Judicial Watch, since we're the only one doing it, to hold those who broke the rules accountable. Now, our first step in that regard was filing an ethics complaint against Cory Booker with the Senate Ethics Committee. Cory Booker, the Democrat senator from New Jersey, I think, who has presidential aspirations, made a fool of himself during the Kavanaugh hearings. Remember that "I am Spartacus" moment, where he said he was going to break the rules to get the records out. Well, he actually didn't break the rules at that Spartacus moment, which kind of made it into a joke. But he later admitted to breaking the rules when he put records out that he wasn't allowed to under Senate rules onto the internet. And the violation of those rules would require, if he's found liable, his expulsion from the Senate. Now, do you think the United States Senate wants to expel Cory Booker or go through that acrimony involved in doing so? No, they do not. That's, again, why they need to hear from you about enforcing the rule of law and Senate ethics rules against Cory Booker, who basically overturned the table, metaphorically speaking, during the Senate confirmation process of Brett Kavanaugh. So you've got this internal enforcement that's necessary, but also you had this external pressure. You had Dr. Ford come in and testify, and people have raised questions about her testimony, rightly so. I was in attendance at the hearing where Ford testified, and it was interesting because I saw the Democrat dishonesty. The Republicans, in many ways, didn't know what to do about what was going on because it was a show trial hearing, and they didn't want to be there. But Christine Ford had a bunch of lawyers with her. And there was an interesting part of the testimony where the representative for the Republicans was questioning her about whether or not she was informed that the Senate majority was willing to go out to California and visit with her and talk to her, which may have obviated the need for a hearing. And here's the testimony. The testimony is this. Remember the prosecutor, Miss Mitchell, who was questioning Ford? She wrote, she questioned her saying, "Was it communicated to you by your counsel or someone else that the committee had asked to interview you and that they offered to come out to California to do so?" Now the lawyers interject and don't want her to answer it because it might involve attorney-client privilege. So there's some back and forth, and then she finally says, "I just appreciate that you did offer that. I wasn't clear on what the offer was. If you were going to come out to see me, I would have happily hosted you and had you had been happy to speak with you out there. I just did not. It wasn't clear to me that was the case." Well, that's a real problem for her lawyers because under the ethical rules, her lawyers are obligated to tell her of such offers. And that's why it was Judicial Watch who this week filed an ethics complaint with the Office of the Board of Professional Responsibility of the District of Columbia Court of Appeals, essentially the D.C. Bar, against Dr. Ford's three lawyers, Christine Ford's three lawyers, Deborah Katz, Lisa J. Banks, and Michael R. Bromwich. And this is what the complaint says. In not informing Christine Ford that Chuck Grassley and the Republicans offered in a letter to fly female staff investigators to meet Dr. Ford in California or anywhere else to obtain her testimony, Ford's lawyers violated the following District of Columbia rules of professional conduct. Rule 1.4a, a lawyer shall keep a client reasonably informed about the status of her matter and promptly comply with reasonable requests for information. Rule 1.4b, the lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. I just read to you Christine Ford's testimony. Does it sound to you like her lawyers had explained to her that the Republicans would have flown anywhere, anytime, any place to meet with her and take her testimony and her information? Of course not. So that's why we filed the ethics complaint. And specifically, we said, it is clear by Dr. Ford's own testimony that her attorneys did not communicate the committee's multiple offers to take her testimony in California. Despite knowing of Dr. Ford's strong preference not to travel to D.C., it was inexcusable that Dr. Ford's attorneys should have neglected to inform her of the fact that committee investigators were willing to meet her. And as we point out, quoting the rule, Dr. Ford was thus deprived of the ability to participate intelligently in decisions concerning the objectives of the representation and the means by which they would be pursued. Okay? But, you know, just so you're clear, we know what this was about, and we highlighted in the letter. It looks like the lawyers subordinated their client's interest in avoiding the publicity of a Senate hearing and avoiding travel to Washington, D.C. As I've long said, this hearing did not need to take place. These allegations could have been dealt with in private in a way that would have protected Dr. Christine Ford and Brett Kavanaugh. But the leftist partisans in the Senate didn't want that to happen. And evidently they were working and had help with their lawyers, her lawyers. Again, in avoiding the publicity of a Senate hearing and avoiding travel to Washington, D.C., these interests were subordinated to the desire of Democratic senators on the committee to have such a hearing take place in Washington, D.C. And we say the failure to inform her of this was dishonest at worst and careless at best. And either way, it was inexcusable. And this is why the D.C. Board of Professional Responsibility, the bar, that enforces the ethics rules for lawyers here in the District of Columbia, needs to take action. And again, it's just Judicial Watch doing this. Because, look, you watched the hearing. I guarantee you, if you're watching this, you were probably watching the hearing too. I was sitting there as this testimony was given, and I saw, oh, there's problems there for her lawyers. Because if she didn't know that she could have avoided all of this because her lawyers failed to communicate with her, that's a big deal. But of course, it's only Judicial Watch that has the backbone to follow up with an ethics complaint with the D.C. Bar.